All right. Today is day 1 of criminal law class. When you check the date, it is 18th of February 2025. 18th February 2025. And if you check your time well, it is 9:27. 9:27. And then today we are going to embark on lesson 1 of criminal law, which is the concept of crime and criminal law part 1. The fact that I've added part 1 means that we have part 2. And I call this the introductory aspect of the topic or of the course. And why must we always begin from here? In fact, I don't know you do, but the little experience I have in teaching from accounting aspects, economics aspects, the law aspect, mathematics, the little that I know is that the introduction to the course is what prepares the mind of the student, or let me say, the learner, to understand the concept of that course, or to understand what that course stands to purport. From that conspectus, I have always desired to take my introduction serious, because the introduction is what is going to help the learner to understand what that particular subject or course stands to communicate. So we are going to spend 2 lessons on criminal law, which is going to prepare our mind, which is going to shift our focus, our attention to the concept of crime and criminal law. We need to understand this because it is going to help us to understand and to be able to substantiate and differentiate criminal law from the other types of law. In fact, before we start, criminal law is different from contract law. It is different from law of torts. It is different from constitutional law. It is different from immovable property. It is different from labor law. It is different from public international law. It is different from administrative law. So you need to understand what criminal law stands to purport, so that as a lawyer, when a case comes before you and you are listening to it, you'll be able to know that the case falls within the context of what? Criminal law. Being able to substantiate or segregate and group the cases that come to you is also a skill that must be developed, or that must be improved. So when a case comes to you, you should be able to know that this one falls within law of contract. And within law of contract, which area of law is that? Which one does the issues embodied around? So we should be able to understand the introductory aspect of the various laws. That is the reason for me spending 2 lessons. That is the reason for me spending 2 lessons on the introductory aspect of the course. So we are going to learn the concept of crime and criminal law. The concept of crime and criminal law. The concept of crime and criminal law. Now, by the end of the lesson, by the end of the lesson, what do we have at hand? What should we have in mind? Well, we are going to introduce it. Then we look at the definition and elements of crime or offenses. Then we look at crime and civil wrong, classification of offenses, definition of criminal law, sources of criminal law, aims and functions of criminal law. These are going to be our agenda, the things we are going to discuss for today. So look at them, take a sip of water, grab your pen, your jotter. Do not sleep. You can sit in your stuffing chair, you can sit on the bed, But please do not sleep on the bed. If not, temptation can overtake you. Make sure to be jotting down something. And we are going to move in orderly manner. Forgive me. I come from Ashanti region. So my R and my L, forgive me. So we are going to move in order as how they have been listed here. If that be the case, we are also going to use the 1992 Constitution of the Republic of Ghana. Number 2, the Criminal Offences Act 1960 at 29. Then we are also going to use case law. These are the authorities that will be running through criminal law a lot until you finish. Though we have other notes or materials that learned authors have also written on some of the issues. However, I must communicate to you that the 1992 Constitution of the Republic of Ghana, the Criminal Offences Act 1960 at 29, case laws are going to be the authorities we are going to use most. Though we have Criminal Procedure Act, which is at 30, that one is also there. However, remember what I've said. We are going to use the 1992 Constitution. We are going to use the Criminal Offences Act, Act 29, case law, and then sometimes the criminal procedure. These are the authorities we are going to use. Pay attention to them. You must have them in mind right now. Act 29. There is no need to be quoting Criminal Offences Act at 1960 Act. It is too long. If it is too long for you, it is Act 29. Simpliciter. Or Act 30. Act 30 is criminal procedure. The procedure they pass through to handle criminal matters. And then Act 29 also talks about the offenses, criminal offenses. It is the one that will let you know what is offense and what constitutes an offense and what does not also constitute an offense. That is the Act 29. All right. Remember our outline. We said that we'll be treating them in order or in sequential arrangement or in sequential order. Number 1, introduction. Are you ready? We are going. When we talk about criminal law is about crimes or offenses. Criminal law is about crimes or offenses. So when you look at criminal law, subject to section 1, please, because you are new, I will take my time. Those of you who are shocked or who have already learned it, please, I beg, forgive me. Some of the things I will repeat myself, some of them twice, some of them thrice. That is how I mostly teach. The reason being that some people grab it in the first line, others for the second line, and the slow learners, we too, we take it on the third line. So most often I will repeat myself. It doesn't mean that I keep on repeating myself, no, but that is my strategy. That is how I used to teach. Because I believe that by the end of the class, at least there should be certain things that will have to be resounding in your ears. So forgive me for that. Now, criminal law is about crimes or offenses. The next one is that because you are new to law, law has its own languages. So when I see a language that I see to be a little bit strange to you, I will make sure to explain that one too. So at the beginning, let me say first semester, I struggle a lot because I have to calm down to the languages of my students, where they are coming from, the field they are coming from. Those who are coming from accounting have to come to their field. I have to calm down. But from a second semester going, by then you'll be abreast with the law terms or the law languages, and then it will be smooth for us to move. So criminal law is about crimes or offenses. crimes and offenses according to the Criminal Act, which is Act 29. These two words could be used interchangeably. They mean the same thing. When you say a crime, it also means or refers to, or it also means an offense. And we are saying that these two words could be used interchangeably according to the Criminal Offenses Act 1960 at 29. They could be used interchangeably. So henceforth, if you hear an offense, he has committed an offense. It's the same as he has committed a crime. Sorry, he has committed a crime. So he has committed an offense. It's the same as he has committed a crime. Understand it. Now, subject to Section 1 of the Criminal Offences Act, which is also known as Criminal Code Act 29. That is what I mean. And the criminal procedure is Act 30. Now, subject to Section 1 of the Criminal Act, it refers an offense to us as a crime. So it means that a crime and an offense are used interchangeably, subject to Section 1 of the Criminal Offences Act. What does Section 1 of the Criminal Offences Act stands to communicate? That is the interpretation aspect of the Act. Now, before we move on, Constitution is being opened in articles, clauses, and paragraphs. Articles, clauses, and paragraphs. So in Constitution, we say that Article 1, the sub, when you're coming down, sub is clause. Then under the clause, the sub is paragraph. Understand this right from the beginning, because you need to understand the language so that when I quote it, you can refer to it in your Constitution. So a Constitution is being opened in articles. You come down, you come to clauses. You come down, you come to paragraphs. So some people prefer to say that Article 1, Clause 2, Paragraph A. Article 2, Clause 1, Paragraph B. Some people prefer to say that. But in legal language, that isn't appropriate to say Article 1, Clause 2. No. You begin from the down to the top. Paragraph B of Clause 1 of Article 2. That is how we do it. Or Clause 3 of Article 1. Or Clause 2 of Article 1. In legal language, that is the most appropriate way of saying it. Understand it. Now, we have established the synopsis or the conspectus that Section 1 of the Criminal Offences Act provides that offenses has the same meaning as a crime. I think we have to feel how it looks like. So I think, Mr. Kweku, you are the one who has the Criminal Offences Act. Can we read from Section 1 of the Criminal Offences Act, Section 1? Mr. Kweku, Section 1. I don't know whether you could see it. Look at it. I think it is in definition, right?
Yes, please.
Once it is definition, it has been arranged in alphabetical order. So look at C, crime, or O, offense. So check C, crime. It is like a dictionary. Please. Okay, thank you. Let's go.
Crime means any act punishable by death or imprisonment or fine.
Very good. So it is any act that is punishable by death, by imprisonment, by fine. By death is talking about the, let me say, first degree felony. Then by punishment, we are coming down, second degree felony. Then we come to by fine. We have misdemeanor. So we have levels of punishment. When you check it, we have an offense. Offense also has been categorized in that order. So a crime and an offense have the same meaning. That is what I want you to understand. Let's put that one down. Now, what therefore is criminal law? At least we have understood that criminal law came from at least the word crime. Crime. There's a crime element. That's why we got criminal law. There's a crime. There's an offense. That's why we got a criminal law. But what therefore is a criminal law? Let us understand that before we even enter the concept very well. When you talk about criminal law is instituted as a mechanism to protect society and the individual against injuries that humans are capable of and have shown themselves to be capable of inflicting on other humans and institutions. So when we come to the society that you find yourself to be, the society that I find myself to be, anything that we see in the society that this thing is capable of causing injuries to the people in the society, this thing is capable of causing harm to the people in the society, then the society come together to put their mind together and then they try to criminalize it. So sometimes there could be an issue or there could be a matter that will be a crime in one society but might not be a crime in another society. This means that criminal law, one way or the other, is societal responsive. It is societal responsive in the sense that it looks at issues or matters that are in a particular society which is likely to cause injuries or which is likely to cause damage or which is likely to cause harm or to hurt the people in the society, and then it criminalizes it. So it is a mechanism to protect society, criminal law. It is there to protect the society. And the individual people, what is a society? Society is about you and I who finds ourselves within a community. That is the society. So it protects we the human being against any injuries or any potential injury. That is criminal law. It is aimed at forbidding conduct that threatens to do substantial. That threatens to do substantial harm to society, even if the victim is just an individual. Yes, criminal law is there to make sure to restrict and to forbid or prohibit conduct that threatens, all conduct or any conduct that threatens to do or to cause a substantial harm to our society. So if we are in a society and then we get to know that this particular conduct keeps on worrying us, this particular conduct keeps on worrying us. So it could be that there is a refuse dump there, and then each and everyone go there and dump refuse. But of late, you have observed that people don't go to the site itself, but they just stand somewhere and then they start spreading the thing, the refuse dump, or let me say the refuse around, which actually or eventually causes sickness to the community or the people within the community. So as the community leaders or the people continues to observe that, then they sit down and say that no, this kind of conduct, we are not going to tolerate it because it is causing harm to us. And then they try to sit down and institute laws to regulate such incidents. So it means that for criminal law, it is the people themselves or the society who decide to let it become a law. So criminal law becomes a law or a matter falls within the context of a criminal law if the society says enough is enough. So anytime you are in a society, and then you see the people, the gong beater and the palace people going around and say enough is enough. Go. the chief says that if anyone does this, then you see that criminal law has come there. I'm just using that one, the one that is very close to us in our society. So it means that when the society, at the moment the society says enough is enough, then criminal law comes there. Enough is enough. We can no longer tolerate it. Then criminal law comes there. Because criminal law seeks to protect the society and the individuals. Yes, indeed. What you did or what the accused did, I mean the person who has done the wrong. What the accused did, possibly and probably he did it to only one person. The victim might be only one person. Yes, it is Mamia Koshia Mansa, whose daughter was raped. Yes. However, the entire society will say that no, we don't like this conduct. So criminal matters are matters that are so dangerous to understand that one person cannot just say that, oh, it just happened to me, so the rest, it doesn't concern you. It concerns us. That is what makes criminal law a public law. So criminal law is a public law. It is a public law in the sense that when you do it against one person, you don't just sit down and say that, but you, it wasn't your daughter that I raped, so it doesn't concern you. It doesn't concern me. It concerns us. Criminal law is a public law in the sense that you can't just rise up and say that, but it wasn't your daughter that I shot or I killed, so it doesn't concern you. Keep quiet in the society. We can't keep quiet. Criminal law is a public law. So an armed robber cannot rise up and say that, but it wasn't you that we robbed. We robbed only the rich man. So it doesn't concern you in the society. It doesn't concern us. It concerns us. So now you understand it. It is the society that is criminal law. So simply the criminal law is an instrument of safety. That is what we use to bring safety in the society. It's also aimed at forbidding conduct that threatens to do substantial harm to society, even if the victim is just an individual. I have explained this. And that is what makes it a public law. I have explained that one too. So criminal law is institutionalized because crimes are not just infringements on private rights. It is public law because infringements crimes are not just infringements on private rights. When you talk about private rights, it is like contract law. See, contract law, you sat down and I sat down and we decided to enter into a contract. And then I told you that I'll be giving you 10 cedis. And then you said that, okay, in exchange for my Toyota car, that one is between the two of us. It doesn't concern anyone. It is a private law. It is a private law. It is a private law because it is between you and I. You and I, we decided to agree, to accept. That's all. Go and weed my farm for me. Yes, when you come, I'll give you my house. That one is lies between the two of us. It's just private law. But for criminal law, it doesn't only lie between the two of us, but the society is also concerned. The society is also concerned. It concerns the society. That is criminal law. So criminal law is institutionalized because crimes are not just infringements on private rights, but because crimes have a particular harmful effect on the public as a whole. When you hear that armed robbers have robbed Mamia Koshia Mansa, I'm telling you, whether you're a military person or you're a security of official or a staff, you too, you will not have a peace of mind. So when you see that, or when you hear that someone has raped someone's daughter, you too, you start sitting all your daughters down. You will never have a peace of mind. Therefore, it is a public law in the sense that it affects the entire society. Understand what criminal law is so that you know that it is different from law of tort. It is different from contract law. That is the introductory aspect. I just want you to understand that. Again, criminal law does not instruct us to do, it does not instruct us what to do per se. What do we mean by that? Look at it. Criminal law is not a Bible. It will not tell you thou shalt not kill. No. Criminal law will not tell you thou shalt not steal. No. Criminal law only tells you the punishment for stealing, but it doesn't tell you not to steal. It doesn't tell you not to rape, but it tells you the punishment for raping. So it doesn't tell us, or it doesn't instruct us what to do per se. Rather, it indicates consequences that may attend upon engaging in a specified form of conduct. Understand it. And then it is important to know that the nature of a crime is such that it is unsafe to leave it redressable by compensation of the individual victim. What do we mean by that? When we talk about criminal law, why did we bring criminal law? Why criminal law? How does it look like? In fact, look at it. In fact, look at this one. Under law of contracts, under law of tort, which focuses on the private right, when a harm is being caused or a wrong is being caused or a contract is being breached, for that one, you can call for damage, or you can call for compensation. You can call for compensation. Now, let me ask you a question. For contract, when someone breaches the contract, you can call for damage, you can call for compensation. Law of tort, damage, compensation. But let me ask you a question. In criminal law, if A killed B's son has been shot, and then A go and say that, well, your son who is dead, let me give you 5,000, and then we just settle the score. Do you think it is normal, or do you think it is appropriate? No. If we can just pay compensation for committing a crime, then I think that is nice. That lady who has been passing by my house, I can save money, make sure to get money in my account, which is well enough to compensate. And then when the lady is passing by, I just let my guys grab the lady and bring her to my room, and I rape her. After raping her, I say, after all, is the money. Money does everything. Money, that's all. Money, that's all. Oga make you carry on. Chinchon chuku di babu. Kola de lafia. Tusala bina wana wojina guna ngwangwa. No go fio, no go mini. Take the money and go. Money speaks. Money. Then I just compensate. If we encourage this in our society, my question is, how would our society be? So we are saying that criminal law, the nature of a crime under criminal law is such that it is unsafe to leave it redressable only by compensation of the individual victim. So under criminal law, we don't talk about compensation. Yes, compensation will come, but the sole aim is not the compensation. Criminal law is there to punish. Eye for eye, tooth for tooth. You do me, I do you. Moses law, criminal law. So criminal law, the punishment is severe, it is heavy, in the sense that we want to demoralize, we want to get rid of such acts in the community because we don't like it. All the people in the community frowns on that. We all, those who go to church, those who also do not go to church, the Muslims, even the traditionalists, all of them are saying that this conduct, we don't tolerate it. That is what criminal law seeks to address. And we are saying that the crime, it focuses on crimes, and then it does not accept what is called compensation as the sole punishment or a tool for punishing the accused or those who commit such acts. So understand what criminal law is trying to say. Now, basically, we are saying that we have two divisions of law. Two divisions of law. So the law of modern state, or our modern state, is divided into two categories. It is divided into two categories. It is divided into two categories. We have we have public law and private law. I think I've taken my time to explain this. So, for the purpose of expanding our knowledge, let us look at them. Public law includes constitutional law. So, the constitutional law you are coming to do or you are doing is a public law. Criminal law is a public law. You see, constitutional law, sometimes a parliamentarian can send an issue to court and say that, well, it is an issue that is affecting the entire Ghanaians. So I'm not happy that it should continue. No, it should be discontinued. And then he sends the issue matter there. Yes, well, possibly and probably it might have not affect, it might be not affecting the parliamentarian, the MP himself, but he's speaking on behalf of some group of people. Therefore, it becomes a public law. It's a public law. Then we have what is called administrative law. Administrative law. Administrative law. So when you read the case of Awuni versus WAEC, you will see when WAEC cancels some of the students' results without consulting or without consultation. And then one person took the matter and then sent it and pushed it, and then the case was being reversed. So we have public law and then we have private law. I have seen one hand up. I will call you in very soon. So we have private law and then we have public law. Private law, we have law of contract, law of tort. We have law of property or immovable property. Before I start another session, I always pause and take questions. So we are within section 2 of our agenda or of the things that we are supposed to discuss today, which is definition of a crime. Your questions are welcome. Counsel. If there is no question, then we are entering to section 2. As I always do, I will make sure to use about 1 minute to recapitulate what we have done so far, of which we are entering into part 2. So far, what have we done? So far, so good. We have looked at the definition of a crime and an offense. And we have seen that when we talk about a crime and an offense could be used interchangeably. So when you hear a crime and an offense, they mean the same thing. You should understand. Again, we have also spoken about criminal law as a law that focuses on the society. Things that the societies are saying that this thing, enough is enough. We are not interested in it. We are not going to tolerate it. And then the society comes together and they say that no, because we don't like it, because we are not going to tolerate it, because it is a taboo to us, then we are not going to accept it. Those are the things that criminal law focuses on. Therefore, there could be certain things that are crime in certain areas, but when you go to other jurisdictions, they are not crime. That is why when you go to the Arabian nations, or let me say, I think that is the most appropriate, or Asia, when you go to the Asian countries or the Arabian nations, when you go there and you touch a lady just like that, you're putting yourself into trouble. I hope you are getting it. But when you come to Ghana, you can hug a lady just anyhow. But when you go to Saudi Arabia, it is inappropriate to do that. It is inappropriate to do that. So that is how it is. So we are trying to say that what the society frowns upon or what the society dislikes, and then they make sure to criminalize them for them to become a crime. That is what the criminal law focuses on. Criminal law focuses on what the society says we don't like. We are not happy with this. We don't want to see it. That is criminal law. That is criminal law. All right. Now, definition of crime. Definition of crime. There are various definitions of crime. We are going to analyze some of them, and then we move on because we can't finish with all of them. A lot of learned authors have given definitions, several definitions on crime. Now we have Blackstone's definition. I think Miss Amma, are you there?
Yes, counsel.
Yes, please, counsel. You are very good. Counsel is the name that we use. So Council be helping me from here going. So let's go. Blackstone's definition.
Blackstone's definition: an act committed or omitted in violation of a public law, forbidding or commanding it.
Thank you. So what Blackstone is trying to let us understand is that when you talk about a crime, what therefore is a crime? He said that, oh, well, if you want to talk about a crime, then it is an act that has been committed. Please remember this under criminal law. We have acts of commission and acts of omission. Like I said, I'm changing your language gradually. So understand the terminologies. We have an act of commission and we have an act of omission. When you talk about an act of commission, it means you doing something. And then when you talk about an act of omission, we are saying that there are certain things you don't do them, but they constitute an offense or a crime. Please forgive me from here going. When I say an offense, like you should understand, I miss a crime. So I don't want to say or again. Very good. So when we say act of commission, it is trying to let us know that there are certain acts that when you doing them constitute an offense. Doing them. Then act of omission, not doing them. So there are certain things that when you do, that one constitutes an offense. When you kill someone, it's act of commission. When you shoot someone, it is act of commission. When you commit armed robbery, it is act of commission. When you steal, it is act of commission. Rape, it is act of commission. Genocide, act of commission. What else? Kidnapping, act of commission. So that one, it is an offense. Then we have an act of omission. Why do we add that one to it? Act of omission. Because when God created us, He gave each one of us our freedom to do certain things. At least if nothing at all. I remember when I was in car traveling, I was reading Article 12 again. Article 12 downward. Article 12, 13, 14, 15, 16, 18, 19, which talks about the fundamental human rights. You have your right to do certain things and you have a right not to do certain things. Yes. So if I say I won't do certain things, why should the law say that my failure to do it constitutes an offense? Can you force me to do it? Does that one doesn't it violate my right and my freedom to do something? So the act of omission, why is it that one also could constitute an offense? Yes, indeed. It's not everything, but there are certain things we are trying to let you know that you haven't done it. Yes, you were sleeping. Yes, we accept it. You were sleeping. You are not the one who did. You didn't do anything, but it can constitute an offense. Number one, whilst you are moving forward, you understand most of them, but I'm just bringing some in so that you understand them. Number one is failure to provide the necessaries of life for your wife and for your children and for people who directly falls under your care. If you fail to provide the necessities of life, if you fail to provide necessities of life for your wife, for your children, or for people who are directly under your care, if you fail to do that and harm befalls them, the law will hold you responsible. Your wife is there, your wife is sick, you're supposed to provide necessaries of life. You are supposed to give chop money to your wife. You don't give, something happens. Possibly your wife dies out of that. Yes, you're going to be held responsible. You're supposed to take care of your child. Your child is at the hospital and you refuse to take care of your child. When harm befalls your child, you'll be held responsible. When you fail to provide the necessities of life for your children or for your wife or for anyone who is directly under your care, you are in a house with a housemate or whatsoever, the person is sick, and then you just jay your eye, you take your eye off just because the person is not your child. If harm befalls the person, you have committed a crime or an offense. Those people who also take care, let me say they who take care of the aged people, the housemates or how do you call them, home care people or how whatsoever. I don't know how you call them. But those who take care of, let me say, the aged people, or you see, you have a child, a baby child, and then you have entrusted, because of that, you have gone for, let me say, a housemaid or a caretaker for the person to come and take care of your aged mother or your aged father or your child. If that person also acts recklessly or fails to act, and then something happens or harm befalls the person that he or she is supposed to take care of, that person will also be held accountable for that. So that's why we are saying that when you talk about a crime, it is not only you doing it. No, sometimes if you don't do it, that also is a crime. To understand the definition, an act of commission or omission in violation of public law, forbidding or commanding it, that is a crime. Counsel, let's go.
Professor Kenneth's definition of crime. Crimes are wrongs whose sanction is punitive and is remissible by the crown, if at all.
All right. So Professor Kenny is trying to let us know that when we talk about a crime is anything that when you do that, the crown, it is talking about, you see, England. When you see something like this, it's talking about England. So he's saying that it is anything that when you do, and then the crown, whether the queen or the king, when he or she sees it, we say, this thing that you have gone too far. You have gone too far. We punish you. Then he's saying that thing constitutes a crime. But you see, I have a problem with all these definitions because they are not telling us specific things that constitute a crime. If you say, crimes are wrongs, whose sanction is punitive. So are you telling me I should finish committing the thing? After I've committed the thing, then you say that it is a crime. No, that is absolutely wrong. After all, even the Bible says that when you don't know it and you commit it, your punishment is less. But if you know it and you commit it, your punishment will be doubled. So I have to know that this is a crime, this is wrong, this is no. If you do this, this is the punishment. If you do that, this is the punishment. If you do this, this is the punishment. So failure to communicate to me in clear terms that this constitutes a crime, and after I have committed it, and you now come and tell me that this thing that you have done, it is a crime, and then the punishment is life sentence. That is absolutely wrong. You should let me know the punishment being attached to what I'm going to do, so that I weigh it to get to know whether it is appropriate for me to do or not. I was listening to a news. No, it wasn't a news. I was listening to, I think it was an interview on UTV or so. I think it is UTV, where Bulldog, I don't know him, but you see, because of law, you should be following all these things. When Bulldog was talking, and then he said, the very time President Mahama was being sworn in, and then he realized that President Mahama has come into governance, the first thing he did was to call his lawyer. That you see, Takoradi Second-New Road, the former president's statue that they have put there. He said he called his lawyer and asked the lawyer, please, if someone destroys a state property, what is the punishment? And then the lawyer said, the maximum is misdemeanor. He said, misdemeanor. If it is misdemeanor, and then it is not life imprisonment or whatsoever, then please, I'm going to wear former president's statue ways to go and then destroy it. So what am I trying to use to support? I'm trying to use this to support the assertion that sometimes when you know the consequence of the offense, it will help you to weigh whether to do it or not to do it. So it is unfair for you to finish doing that thing whilst you don't know the punitive measures. And then after you have finished doing it, they come and tell you that this thing that you have done is life imprisonment. It is absolutely wrong. Absolutely. So that is what that's the critic or the pitfall within these definitions. So let us look at Granville Williams' definition. Yes, counsel, a crime.
A crime is a legal wrong that can be followed by criminal proceedings, which may result in punishment.
Counsel, so going along with you, you and I could see that all these definitions are let me say, how should I put them? They are not able to let us know what a crime is. They have not been able to communicate to us in clear terms what constitutes a crime and what does not constitute a crime. All of them are just saying that you look at the Glenvar. Glenvar is saying that that is followed by criminal proceedings. So you mean that I should go and finish doing the 10? I should finish with the 10. I should commit the offense, and then the criminal proceedings comes before I get to know that this thing is a crime. No, that is absolutely wrong. At least God said that thou shalt not kill, thou shalt not do this, thou shalt not do this, thou shalt not do this. After the Lord has given the 10 commandments, then he came down to the curses. If you do this, this is the curse. If you do that, this is the curse. If you do this, this is the curse. That is how a law is supposed to be. But you can't just say that something is a crime. It is a crime because after doing it, you'll be punished. Abba. So should I finish doing it before I get to know that it is a crime? So there's a pitfall with all these definitions. Let us look at Mensah Bonsu's definition.
Mensah Bonsu. The general notion of crime escapulates any act which is expressly prohibited by a statute in force or by the common law with penal consequences.
Mensah Bonsu, I like definition, but I also have critique. All these ones, I am criticizing them from the little that I know. You too, you might get critique somewhere, or you might also critique what I'm also saying, or you can argue. It is law. It is law. So you can argue what I'm saying. You can argue. You can agree with me. You can also disagree with me. But me, what I disagree with them is what I'm trying to prove. When you look at Mensah Bonsu in his book, that's the definition he gave. Mensah Bonsu gave. He said that it encapsulates any act which is expressly prohibited by a statute in force. So the word is expressly prohibited by a statute. Congratulations to this person, this learned author. Expressly prohibited by a statute. It means that anytime you are being told that you have committed a crime, according to Mensah Bonsu, if someone tells you that you have committed a crime, the first thing to ask is, where can it be seen in a statute? Show me the statute that tells us that we shouldn't do this, because it says that an act which is expressly prohibited by a statute. So it means that if you are saying that something constitutes a crime, then you should be able to pinpoint or show me. Go and bring the statute, go and bring the document. And you and I know that when you talk about a statute, we are talking about an act of parliament. We are talking about a document that has been passed by parliament, a statute. So there should be an act that we can make reference to, that this specific act, this specific session, this specific area speaks against this conduct that you have done or you have committed. So that is what Mensah Bonsu is saying. Even if it is in the act, he's saying that it's not supposed to be implied. It is not supposed to be implied. It should be expressed. So he's saying that any act which is expressly prohibited by a statute in force. And then again, he's saying that Mensah Bonsu is saying that, or by the common law with penal consequences. By the common law with penal consequences. That is where I bet to differ. You might disagree with me, but me, I disagree with Mensah Bonsu. You might also agree with Mensah Bonsu, but to me, so far as I'm the one doing the presentation here, I disagree with Mensah Bonsu. For the first part, thumbs up. But the last part, or by the common law with penal consequences, I disagree with Mensah Bonsu. Why do I disagree with Mensah Bonsu? Okay, Council, please go to Article 19. Article 19. Council, are you there?
Yes, please. Yes, please.
So once you are in Article 19, read clause 5 for me.
Clause 5. Okay. Article 19, clause 5. A person shall not be charged with or held to be guilty of a criminal offense, which is found on an act or omission that did not at the time it took place constitute an offense.
Very good. Read it for the last. Okay, let me explain it. Then you read it for the last time, for the sake of those who are now new to the law terms. You see, Article 19, clause 5 is trying to let us know that nothing must constitute an offense. Look at the previous definition we gave, of which we are coming. Article 19, clause 5 is trying to let us know that nothing must constitute, nothing at all must constitute an offense. At the time when the incident happened, there was no statute. There was no statute that was being or that has already been passed, which forbade that incident which has been committed. So it means that now today, let me say today, you have raped person B. Yao has raped person B today. Now, forgive me, I'm coming. Good. So what I'm trying to say is that if, let me say, Yao has raped person A, Yao has raped person A, that is fair deal. Now the question becomes, when Yao was raping person A, was there any law that prohibited such acts? If there was no law, but the law came after Yao had raped person A, then we are saying that that act that Yao did doesn't constitute an offense. But as at the time that Yao was doing the act, there was a law which expressly states that when you do this, it constitutes an offense. Then if Yao overlooks it and then involves himself in such act, then automatically he has committed an offense. Read it for the last time and let us go.
Article 19, clause 5. A person shall not be charged with or held to be guilty of a criminal offense, which is found Article 19, clause 5.
So like what I said, saying it in legal terms most appropriately. A lot of people accept what you are saying. Especially when you are listening to the politicians on TV stations, that's how they say Article 19, clause 5. But in legal terms, that isn't appropriate. You say clause 5 of Article 19. I hope you are getting it.
Okay. Yes. Okay.
So let's go.
So clause 5 of Article 19. A person shall not be charged with or held to be guilty of a criminal offense, which is founded on an act or omission that did not, at the time it took place, constitute an offense.
All right. Cancel? Yes, please cancel. Thank you. So that is what the Constitution means. It means that when an act is committed, as at the time it was committed, there must be a law which says that this act, when you do it, or this act, there's a punishment there. So that is what the Constitution is trying to say. And then I've seen some message here from Nyameche Council. He said, I don't have access to my microphone. Please check your microphone. Your microphone is on your, I don't know whether you're using laptop or you're using a phone, because I've given you access. I've given you access. So you have muted yourself, so you can unmute yourself and then talk if you want to talk. All right. So that is how it is. So simplicity, section 1. So from what we read, Article 19, clause 5, we have seen that Article 19, clause 5, you have seen that nothing is an offense if at the time it was being committed, there was no law that prohibited it. Nothing is an offense. Now let us go to clause 11, the same article. Clause 11 of Article 19. Yes, Council, let's go.
Clause 11 of Article 19. No person shall be convicted of a criminal offense unless the offense is defined and the penalty for it is prescribed in a written law.
Council, do you agree with what you are reading? No person is supposed to be charged for committing a crime unless the crime, the act that the person has committed, there is a law that says that when you do it, you'll be punished. Council, read it for the last time.
No person shall be convicted of a criminal offense unless the offense is defined and the penalty for it is prescribed in a written law.
So unless the act is defined, so the act has to be defined. That is why when you pick the Criminal Offences Act, section 1 is what they have used for the definitions. The act has to be defined. Even when you go to the Criminal Offences Act, it defines what an armed robbery means or robbery means. It defines what kidnapping means, what stealing means. It defines them, and after that, it gives you the punishment. So the Constitution, which is the supreme law of the land, is trying to let us know that nothing must constitute an offense unless one condition, unless the act is defined. Number 2, second condition, with it punitive or punishment being attached to it. So nothing can constitute an offense without its definition and without the punishment being attached to it. So as students of the law, when you are driving your car and a police person stops you and say, hey, you are arrested, the first thing you have to ask as a lawyer or as a student lawyer is that, what is my offense? Then the police person mentions it. You say, can you show me where the offense could be found? Because what I have committed, that offense must be expressly stated in an act. So which act states or talks about this offense? Where is it? Fine. When you get it, then the next one becomes, let me look at the punishment. If there's no punishment being attached to it, then it is not a crime. 2 things. Number 1, the act, or let me say the so-called offense of which you have been accused of, must be defined. It is must, or it is not should. It must be defined. What does it mean? What entails it? What constitutes it? What is the component of it? It must be defined. Number 2, it must have its punitive measures or punitive consequences or its punishment being attached to it. It must be defined. In a written law, it must be defined in a written law. It means that when we talk about criminal law, are you listening? I'm saying a lot of things. So it means that when we talk about criminal law, common law is not there. Why is common law not part? Common law is not a written law. Common law is not a written law. Common law, I repeat myself, it's not a written law. So if Mensah Bonsu is saying that, or by the common law, or by the common law, then I disagree with Mensa Bones. Because criminal law must be written. Yes, criminal law must be written in a statute, but common law is not a written law. Okay, counsel, let me settle my case and my submission with clause 21 of the same article, clause 21.
Clause
Counsel, please.
21.
Yes, my dear.
All persons shall have the right to freedom of speech and expression, which shall include freedom of the. Hey, please,
Please,
am I reading the right?
Article 19, clause 21, no.
Okay, please, so sorry. For the purposes of this article, criminal offense means a criminal offense under the laws of Ghana.
Very good. For the purpose of this article, what article? Article 19. Hey, law is nice, so lazy people cannot do law because they won't put everything at one side. For the purpose of this article, what article? Article 19. Criminal offense means the laws of criminal offense means offense under the laws of Ghana. It is not laws. At least you have done Ghana legal system, and you know that common law we inherited it. So when we talk about criminal offenses, we are talking about the offenses under the laws of Ghana. Because when you go to, sorry to say, Saudi Arabia, and possibly and probably you don't put on the veil, it is an offense. But when you come to Ghana, it is not an offense. So offense or criminal law is jurisdictional, though we have certain things that are widely accepted to be crime, such as killing human beings or committing murder or stealing. Those ones are accepted worldwide. However, there are a lot of things that are jurisdictional. So far as criminal law is concerned, they're jurisdictional. So I am trying to let you know that Mensa Bonsu's definition, the common law aspect, criminal law is not common law. Criminal law is not common law. Because criminal law must be written in a statute, a written statute, Article 19, starting from clause 5, going to clause 11, going to clause 21, to disprove the fact that common law, criminal law is not common law. All right. Now, section 1 of Act 29 provides that crime means any act punishable by death or imprisonment or fine. We are still within the definition of a crime. And I call this one a lazy man definition. Lazy man definition. Crime means any act punishable by death or imprisonment or by fine. I call it a lazy man definition. What is a crime? So I call this one a lazy man definition. Why should I finish committing the thing for me to receive the punishment, imprisonment or fine before I get to know that what I did was a crime? I call it a lazy man definition. So crime means any act punishable. I call it a lazy man definition. So that is how it is. Now, in the case of Armand versus Home Secretary and Minister of Defense of Royal Netherlands Government. Counsel, let's go ahead.
A cause or matter is criminal in nature if it is one which, if carried to its conclusion, might result in the conviction of a person charged and in a sentence of some punishment.
So this one too, I disagree with the person. The question is, why should a matter be carried to the end and face the punitive measures before knowing that it is a crime? Why do you want me to commit the thing and finish doing it and then receive the punishment? Now that I am in prison, or that now that I've been charged with punishment or have been assigned with punitive measures, then that I now get to know that what I did was wrong. No, you should let me know so that at least I exercise some kind of discretion or restraint when I am doing them. So that is how it is. So briefly, what are we trying to say? We are saying that an act or omission is a crime only if it is prohibited by a statute. Underline that one, they are very important. By a statute. and there is a punishment attached to the doing or not doing of that act. To the doing means act of commission, or not doing means act of omission. Our languages are changing. To the doing means act of commission. To the not doing means act of omission. Crime is any act or an omission. Crime is any commission or an omission which is expressly prohibited by a statute in force or by common law. So the common law, I argue it with penal consequences. So when we look at all these ones, when we look at all these definitions, what we have said, we could see that punishment is very important in criminal law. Criminal law, punishment is very important in criminal law. So that is how it is. So periodically, what we are trying to say that periodically, the society reviews and identify actions or omissions that could impede the societal peace and criminalize it or decriminalize it. I have said it earlier that the society looks at the things that they are not happy with it, and then they criminalize it or decriminalize it. In some time past, Ghana, when you're committing suicide and you are being caught, it was a crime, but now it is not a crime. So that is how it is. The society just look at it and they keep on reviewing it. This one, we are not happy with it. Then they criminalize it, or when they see that, oh, this one is enough, it's enough, then they decriminalize it. So that is how it is. All right. A death sentence and suicide are decriminalized. A crime is that act or omission that the state will punish. However, until the state legislates to decriminalize an act, it is not a crime. So it means that what we are trying to refer to is that until the state legislates an act, until the state legislates a law to criminalize an act, it can by no means be called a crime. Remember what I said. A crime must be found in a statute. It must be defined. So if the state had not legislated a document or a statute to criminalize it, then it can never be qualified to be called a crime. That is why a lot of people criticize Statutory Charter versus the Republic. That case, Statutory Charter, willfully causing financial loss to the state. The politicians know this case a lot. Willfully causing financial loss to the state. We will analyze that case under our lesson 2 of the introductory aspect before we enter into the criminal law properly. So we are still within the introductory aspect. I'm trying to prepare your mind for you to know what criminal law is about. Crime, and criminal law, crime. So when you hear crime, offense, then your mind has to come to criminal law. It is about crime and offenses. Crimes or offenses. And then we are saying that nothing is a criminal law until the society makes it so. It is one of the questions discussed. Criminal law is not until the society makes it so. Discuss. Criminal law is not until the society makes it so. Discuss. Or nothing is a crime until the society makes it so. Discuss. It means that nothing at all is a crime until the society now sit down and say that no, this thing is impeding our peace. This thing is too much. It is hurting us. We don't like it again. We are no longer interested in it. Then they come together and then they make sure to present it. That's why we have MP, Member of Parliament, who are representing constituencies or the areas. They present such incident, and then when the state realize that, oh, this thing is no good, then they legislate. The Parliament legislate. It goes to the government or the president. Then all this one later on, it finally becomes an act. So the state legislates to criminalize that act, and then it becomes a crime. So until a statute is being passed to criminalize such an incident, then it can by no means be called a crime or an offense. So that is how it is. It means that criminal law is being instituted by the society, the people themselves. We don't like it. Then we make a law against it. We have analyzed all this. Article 19, Clause 5 of the 1992 Constitution, a person shall not be charged with or held to be guilty of a criminal offense which is founded on an act or omission that did not at the time it took place constitute an offense. At the time the person did the thing, there was no law. Tetuti Carter versus the Republic, Hassan versus the state. We look at all these cases, Hassan versus the state, Tetuti Carter versus the Republic. We talk about all these cases in our second lesson. So this talks about the predictability quality of the law. The law must be progressive, but not retrogressive. Assuming the law is going to be retrogressive, it would have been something else. So your land that you bought, or your grandparents, great-grandparents' land that they bought so many years ago, and then we are now coming to make law backward to go and say that no, the land that you bought, you didn't buy it by using the appropriate laws. So we are going to take the land from you. How would our world be? So the law must be progressive but not retrogressive. So that is clause 5 of Article 19, what it is standing to purport. Then clause 11 of Article 19 says that no person shall be convicted of a criminal offense unless the offense is defined. So now we know that criminal law must, anything that constitutes a crime, that thing must have a definition in a statute, not necessarily in the Criminal Offences Act 29. No, it can be in the Income Tax Act 896. It can be in the Labor Law Act. It can be in the Land Act at 1036. So anything, anywhere, there must be an act. There must be a statute. There must be a statute. There must be an act that criminalizes the act. So, or the conduct. So we are saying that clause 11 of Article 19 is trying to say that those acts must be defined, or the so-called crime must be defined, and then it must have a penalty, and the definition must be in a written law. It must not be anywhere just like that. No, it must be in a written law that we can pinpoint that, oh, it is in this written law, it is in this document, it is in this statute. Then that we can accept that a violation of it constitutes a crime. So written law here means that in Ghana, common law matters are not applicable in criminal law. Yes, simplicity, unless the law is written with punitive measures or sanctions, the breach thereof cannot be criminal or cannot be a crime. All right. So looking at the time, I don't know whether you'll be able to add elements of a crime to it, but I will pause here, take questions, and then after the questions, we get to know whether we'll be able to add this 1 to it, the 2B to it. So let me take your questions. Any question, you raise up your hand, I will take you. And then when we are done with it, we'll look at the way forward. Yes, please, question time.